My name's Joshua Wurtzel, and I'm a partner at Schlam Stone Dolan. Today I'm going to be speaking about disputes between a stockholder and an issuer when an issuer refuses to remove the restricted legend from a stockholder's stock. If stock is registered stock, then generally as a stockholder you can sell it in the public market. If the stock is not registered, then there's going to be a restricted legend on the stock, which as a practical matter prevents you from selling it into the public markets until the restricted legend comes off. One way of getting the restricted legend off is to qualify for an exemption. And perhaps the most common exemption is Rule 144. And at a very high level, under Rule 144, after the passage of 6 months, as long as certain other conditions are satisfied, even if the stock is unregistered, Rule 144 provides an exemption to registration and allows the restricted legend to come off. Now, there are a number of different requirements that have to be met to satisfy Rule 144. And this perhaps becomes most significant when dealing with something called a former shell company. So a former shell company is a company that once was a shell, didn't have any meaningful assets or operations, but is no longer a shell and is in fact an operating company. When you have a former shell company, there are additional requirements that you have to meet under Rule 144 to have the legend removed. One of those requirements is that the issuer has to be a mandatory reporting company subject to the reporting requirements of the Securities Act, and they also have to be current on their filings. There are securities lawyers who provide opinion letters and help put together information and documents for stockholders to then submit to the issuer and to the transfer agent to have the legend removed. When I get involved, that means that there's a dispute between the issuer and the stockholder about whether the legend can be removed. Generally, the stockholder will submit all the paperwork, will submit the opinion letter, and will say, look, I satisfy Rule 144, the legend should come off. And the issuer will say, no, you don't satisfy Rule 144, we're not going to allow the transfer agent to remove the legend. And generally speaking, the transfer agent will take instruction from the issuer in that situation. Why do companies do this? Well, oftentimes it is a small cap company, perhaps a startup, that for whatever reason doesn't want the stockholder to be able to sell the stock. Maybe, and I've been involved in several cases in which the company has a separate dispute with the stockholder, separate litigation or a separate dispute, and they don't want the stockholder to be able to sell the stock because they don't want the stockholder to get the money from the sale of the stock. And the issuer uses its refusal to lift the restricted legend on the stock to effectively hold the stockholder hostage and render the stockholder's stock really without value if they can't sell it. So what do you do in these situations? One of the common things that we have seen is an issuer says, well, I can't lift the legend, or the transfer agent can't lift the legend on the stock because even though we're current on our filing requirements now, we might not be current a month from now or 2 months from now or 3 months from now, and then you wouldn't satisfy the requirements under Rule 144 for a former shell company. So we actually litigated this issue. There is authority for the proposition that the legend can come off even without there being an imminent sale. So what we've done before is we've gone into court and we've gotten a court order that says the next date that a 10Q or 10K is due to be filed is X. So basically the legend can come off and all the stock has to be sold before that date. And that gets around the issue, because if you can guarantee that there are not going to be any 10Q or 10K filings that are required between whatever date the legend comes off and whatever the deadline to sell the stock is, then you're not going to necessarily, the issuer will be current on its filings through the deadline to sell the stock. A common theme in these types of cases is that the issuer comes up with various technical reasons for why the restricted legend can't be removed from the stock. And it's very important as stockholders' counsel to really push the issuer to identify what the underlying issues are, to get them to commit to those problems in writing in advance. Because once they've done that, they've in many ways locked themselves in. And an issuer who is really doing this just to play games, to try to prevent a stockholder from getting access to its shares or to liquidity from its shares, usually the reasons are going to be disingenuous, right? They do it because they know that they can, right? And you've got to sue them and spend money to try to get the legend removed. Right? This is something we've done many times before, and we've had success going to court and getting the legend removed.